This podcast is sponsored by BCH. BCH have been providing flats-specific reinstatement cost assessments for almost 20 years, with the building's insurance premium often contributing to a large portion of a service charge. BCH can provide specialist, third-party, unbiased, RICS-compliant reinstatement cost assessments, allowing the managing agent maximum compliance and best practice and the placement of the most competitive buildings insurance. Their commitment to accessible, prompt and accurate buildings insurance valuations has seen BCH secure the best first step in buildings insurance for over 600,000 flat owners. For a quote, please contact info@bch.uk.com today.
Welcome to another episode of Beyond Four Walls, the podcast that takes you on a journey through the fascinating world of property and beyond. I'm your host, Jodie Fraser, and today I have a truly special guest joining me, Emma Bush. Emma is a partner in the Property Litigation Department and an expert in contentious residential leasehold matters. With a wealth of experience in contested right-to-manage claims, property disrepair and dilapidation cases, service charge disputes and claims arising from the Building Safety Act 2022, Emma's practice covers a broad spectrum of legal challenges. She's appeared in various courts and tribunals, including the County Court, First Tier Tribunal, Upper Tribunal, Court of Appeal and even the Supreme Court. Emma's proactive approach, focusing on alternative dispute resolution and pre-emptive pre-action steps, has set her apart as a leader in minimising litigation costs while achieving successful outcomes for her clients. So join me as I delve into Emma's journey, her insights into the ever-evolving world of property litigation, and her strategies for tackling the most complex legal issues. Emma, welcome. Thank you for joining me today.
Hi Jodie, thank you so much for having me today.
Of course, of course. So can you tell me a little bit about your journey into property litigation? What drew you to specialise in this very technical, crazy world?
Crazy, absolutely. Especially the last 2 years. I don't think we've ever seen an area of law change and evolve like we have in the leasehold sector over the last couple of years. I think if you ask any property lawyer, they will tell you that no one sets out at law school to become a property litigator. And if they do, I would strongly suggest that they're not being particularly truthful. I think the funny thing about a lot of lawyers is that none of us really know what we want to do when we're at law school. You know, in our very early 20s, thrown into, learning all of the various different topics. And for me, initially, it was where could I get a job? And I think that probably would ring true with a lot of people in a lot of professional sectors. I certainly know a lot of property managers I've spoken to have said similar, ended up in the sector with a bit of luck, maybe, or by accident.
Yeah.
So for me, my journey to property litigation was a very winding one. I initially started out back in 2013 as a uni graduate doing residential conveyancing. Started studying my postgraduate legal practice course and took a job doing catastrophic personal injury work. Moving through my training contract, I've worked doing mental capacity and deputyship matters for elderly and vulnerable people, which gave me huge exposure to a lot of issues, including property litigation, sometimes in the aspect of sort of contentious estates work, sometimes dealing with housing associations, rehoming vulnerable adults, dealing with sales of properties to fund care and treatment. So it was always on the peripheral of my career journey. And then just shy of 4 years ago, I got a phone call from a very good friend of mine that I went to university with, who is a partner in the residential leasehold team at Brethertons. And she called me and said, we need someone that specialises in litigation, that understands civil procedure rules, that can dive feet first in and help, mould a specialist leasehold litigation team when they saw a huge increase in that sort of work coming out of their leasehold sector. I interviewed for the team, with peripheral knowledge of property matters, only initial general view on leasehold, never having done leasehold litigation. And somehow 4 years later, I found myself with a fantastic property litigation team, taking on work across the country, levels that I couldn't have imagined that I would have had the opportunity to do, when I was a paralegal
Yeah.
12 years ago.
12 years ago, you were a paralegal, and now you're a partner in your department. I mean, that's incredible. And you're not exactly, old. So,
Well, I think my team would disagree with you.
oh,
I was very much used to being the baby in my office. Yes, I have a fair few realization moments now where I look around the team and realize that I'm one of the most adulty adults in the room.
yes. Yeah, when you get that realization that, people are talking about stuff around you and you don't know what on earth they're saying.
That's absolutely it. I mean, the biggest realization last week is I had a Boots meal deal in the office, and on the side of the meal deal packet it says Boots meal deal first created in 1999.
Hmm.
And I looked around at my team and realised that none of them were born
Yeah.
when the Boots meal deal
Yeah.
first came out, and I just sat there and felt very sad.
Right, that's a little bit crazy. So
Yeah.
tell me some of the common challenges you face with, obviously without naming names and cases, but face with contested sort of right to manage claims or estate litigation or anything like that.
I think that the main issue in the leasehold sector is really boils down to an education point of view. I mean, leasehold is not something we're taught about at school. People buy flats without really being given that foundation knowledge of what that means, what that looks like. And I think those challenges are probably felt across the whole sector through property management, transactional legal work, and the contentious legal work. The difficulties we see are in very poorly drafted leases. We regularly deal with leases dating, back to the 60s and 70s, which, perhaps were fit for purpose at the time, but really don't stand in good stead in the modern sector. Part and parcel of the sort of really difficult parts of that is explaining those challenges to either leaseholders or leaseholder-owned freehold companies, or even professionals in the sector that may not have seen a particular sort of lease drafted in that way before, and trying to explain that leases aren't standard documents, that one lease doesn't fit all purposes is really challenging. Last week I had an inquiry call with a particular property manager who said a company is charging this fee to do this thing, we would like to do that. And I said, well, what does the lease say? Does the lease allow you to recover this as an administration charge, as a management fee? They said, oh, we hadn't looked, but because this large industry body was doing this, we assumed we could as well. It's those regular conversations that I think are particularly challenging, and finding ways that work within the confines of the legislation and the leases, but also resolve general problems with communal living.
Obviously, since the Building Safety Act and all the new fire regulations and everything, I'm assuming that has increased your workload tenfold. But do you still get the odd, my neighbour's got a dog and you're not allowed pets conversations? Does that still come up now with everything else going on?
Oh, absolutely. The Building Safety Act has very much become the majority of the emails in my inbox. I'd say papers on my desk, but we don't have papers on the desk anymore. But yes, we still regularly get sort of non-monetary breach cases, so the noise nuisance, the dogs, the pets, antisocial behaviour calls and things like that. It's very much still sort of bread and butter work that we take on. And actually, it's quite nice occasionally when you get a call that's not building safety related.
Absolutely, I'm sure. How has the impact of the Building Safety Act affected you and your practice?
I don't think I've ever spent so much time reading new legislation.
It changes so quickly, didn't it?
Absolutely, absolutely. I mean, I've lost track of how many sets of regulations we now have, and trying to keep up with the amendments. We have a bit of a poll in the office whether the Building Safety Act or LAFRA has been the worst drafted piece of legislation in our modern legal history. It's a neck and neck at the moment when we come across different sections of each. We're very much having to quickly get to grips with the options that are now available for various different parties, whether they're right to manage companies or leaseholder-owned freeholds or commercial freeholds. So, the challenges differ dependent on who my client is. And because we act across the whole sector for leaseholders, freeholders, leaseholder-owned companies, we have to sort of know the legislation from every angle. And it's definitely increased the amount of litigation, which I don't think was the purpose of the Building Safety Act, but it's become ever so contentious. And, we're now in situations where people are arguing over significant sums of money, which procedurally is a complete nightmare. It doesn't do what the legislation is supposed to do, which is remediate the buildings. It has caused...
And keep people safe, ultimately.
And keep people safe, absolutely. It's caused a legal finger-pointing battle, which is not the intention of the legislation. It's kept me incredibly busy. It's incredibly frustrating for the people living in these buildings.
Do you find then that links in with property disrepair and dilapidation cases, that you have to bring in the Building Safety Act on that as well? But how do you approach cases then if the property is in disrepair, but is it down to the leaseholders then to pay their service charge, but they won't pay their service charge because the property's in disrepair? And do you get involved in all of that, or is that still managing agent territory?
No, absolutely. It's unraveling those webs, is the initial stages. So whenever we look at a new legal case, the first step for us is a review. And that covers various different sort of parts of the problem. I'm a very visual person, so for me, it's almost a mind map out. We've got leaseholders saying that we're not paying service charge because, for example, there's dilapidations. We've got freeholders saying, well, hold on a minute, we can't remediate a building from a non-Building Safety Act perspective without service charges. A lease that's saying, well, the freeholder can't repair a building until they're made aware that it's in disrepair because the lease is more archaic than one would like. And then you throw in on top of that actually this is a 14-metre building and some of the disrepair aspect is the cladding. So you then have to unravel what costs are not recoverable when they were demanded. And, there's now this further layer of complication that's added on to the unraveling of the problem. And the way that I generally approach these things is actually working with our managing agents that we have great relationships with to be able to weed out which parts of this particular issue are going to form part of a litigation, which parts can be dealt with on a more practical level. What can and can't be demanded, for example. Are we dealing with service charge debts, or are we dealing with tribunal applications under the Building Safety Act? And really setting out all of the separate but parallel problems. Something we've seen an increase of recently is the sort of enforcement notices that come from local authorities being woven into those problems as well, and having to unravel that because the tribunal deal with those as a separate jurisdiction to building safety cases.
Of course.
Of course they do.
Just to complicate matters.
Absolutely. Although the issues are the same and the answers are generally going to be the same in terms of what needs to be done. The tribunal have made it clear in a case that they heard last year that the sort of jurisdiction of the local authority, the enforcement notice, the Housing Act claims, and the building safety jurisdiction are things that they will deal with separately. So we have one big problem that could end up being three separate pieces of litigation that potentially are heard by three separate panels of either county court or tribunal judges, as well as dealing with groups of leaseholders and managing agents and freeholders and management companies, and trying to explain to everyone that these are all of the separate issues. So you end up, really running some sort of pantomime with all of these little puppets dangling from strings.
Yeah, and I suppose then, correct me if I'm wrong, but all of these costs are then recoverable via the service charge, potentially. Your costs anyway, is when there's so much press and attention on protecting leaseholders, quite rightly, but then the powers that be, if you like, are saying, well, no, we've got to do this separately and that separately. Well, that's, as you say, three separate sets of litigation with three separate costs, not just from you, but from the managing agent and everybody, around you. But then does it then ultimately fall back onto the leaseholder to pay?
That particularly comes down to the drafting of the lease.
Yeah.
As I'm sure you will have seen, not all leases have legal cost recovery clauses or professional cost recovery clauses. So that's the first kind of hurdle to jump over when we're starting to unravel and look at these problems is actually what is the situation? Are legal costs recoverable? And the added complication to that is obviously costs relating to building safety matters, have their own new rules, if you like, under the building safety. I don't know if we can call them new anymore, now that it's 2.5 years old, but it still feels very new.
Yeah, we'll call them new for now.
the newish rules.
Yeah.
And then obviously you've got managing agents with their fees under management agreements. You then have potentially separate issues if you've got leaseholder owned management or freehold companies. So you've got cost recovery under company articles of association. So really pinning down, how certain causes of action can be funded is a crucial and quite often difficult conversation that we have to have from the outset, because it isn't just a given that our legal costs can go through the service charges. And that's, I think, a really important level of transparency that certainly my team really strive to have with our clients, and say, look, okay, here are all your problems. For example, your service charges won't cover legal advice. You have a really limited forfeiture legal cost recovery clause that you can only recover legal costs relating to a Section 146 notice, for example, which is quite common in sort of leases from the 60s and 70s. And actually, what do you want to do? Do you want to do a voluntary whip round, effectively, of all of the members of the company to fund legal advice and support? Or we can direct you to organisations that can give you some support, but you won't get a representative, for example, to go all the way through the litigation. Obviously, the tribunal is set up effectively for people to act for themselves as litigants in person, but certainly what we see day in, day out is the tribunal system is not actually that accessible for a normal lay person to access. And the rules and procedures still need to be followed. And although the tribunal is more flexible than, for example, the stringent rules in the county court, it's still complex, it still takes time, and someone still has to run those cases. So that's absolutely one of the first hurdles to jump over. And if you've got a lease that does allow cost recovery and your client instructs you to go ahead, you then have to deal with the tribunal's jurisdiction under Section 20C, for example, if it's a service charge dispute, not to have those costs put through the service charges for the members of the litigation. So there's all of these things that we have to be aware of, to advise of, to tick off with our clients before we've even thought about what court papers we're going to draft. And I think that level of complexity in the leasehold legal sector is something that a lot of lawyers perhaps wouldn't appreciate if they don't do this day in, day out. And I feel incredibly fortunate that we have a specialist team, and that's all we do. We're certainly not in our department going to be taking on loads of different cases from general areas of litigation, as well as the leasehold matters, because I think it requires so much specialist knowledge. Otherwise you're going to miss a step, and ultimately that's not good for anyone.
Oh, absolutely. And I'm sure leasehold is keeping you busy enough.
It is absolutely keeping me busy, yeah.
So to flip it slightly on, I've mentioned about alternative dispute resolution. How does that work in terms of minimising litigation costs?
There's formal, sort of two types of ADR. There's formal dispute resolution, that's things like a formal mediation. And what we've seen flowing into the tribunal now, but it has always been prevalent in the county court jurisdiction, and especially as of changes in the civil procedure rules in 2024, I think they were, or 2023, which required mediation as standard. There is an expectation that the parties engage in that prior to utilising the court time or the tribunal time. So one of the things that we will look at that very early kind of risk assessment stage is actually, are these issues ones that could be resolved with a bit of common sense, maybe an independent referee, if you like? Are they actual legal issues, or are they people issues, or are they issues that we can find a resolution to without engaging all of those sort of legal costs? And as much as I'm sure our finance department would slap my wrist for saying that, I don't think legal costs are the way to go in, I would say, 90% of the disputes that we see. Ultimately, you've got communal living, which causes problems in itself. I don't think the human race are really meant to live on top of each other in in blocks, even sharing houses. We see the family departments with increasing levels of divorces, for example. So generally humans living together causes conflict. And one of the things that we will look at an early stage is, can we get everyone around a table, metaphorically or physically, and can we sort of suggest a way forward that is going to save legal costs, it's going to save time, we're going to get a good outcome for everyone involved, and actually we can get this done much quicker than waiting for the court to engage with us, lose our file once or twice, list us for a hearing in 18 to 24 months' time, and have to deal with all the procedural prep that comes with that. Ultimately, no one wins at the end of that. Even the party that gets the decision in their favour is not going to feel like they've had a win, because they've had to wait so long for it or pay so much to get there, and ultimately the problem hasn't been resolved. So from that perspective, I think alternative dispute resolution is incredibly important. From the informal perspective, it's something that as lawyers we have to keep on our radar generally, throughout a process. One of the sort of strongest tools in our toolbox, I think, is being able to pick up the phone to the lawyer on the other side and say, look, let's have a conversation about this. We've got XYZ coming up in the directions diary, or we've got these issues. How can we get through this? And what I really enjoy is actually when I have a good relationship with the lawyer on the other side, ultimately we're not against each other. It's not a battle of wills. And I have to say 90% of lawyers on the other side that I deal with share that view. We get the occasional few that see it as a personal challenge to win. That's just the nature, unfortunately, of people that do litigation.
Yeah.
We're all a little bit argumentative at times, I suppose. But yeah, being able to have those off the record conversations without prejudice, discussions, and really work out a way forward that is in everyone's best interest.
Definitely. And do you find that a lot of your cases, you said earlier that 90% of the cases could be dealt with mediation, or just, but is it something that ends up not actually happening because there's just, everyone wants that fight, or do you get a lot through?
I mean, it's a really good question. There is definitely the proportion of cases where people want their 10 minutes in court. They want to be able to say their piece, and there's probably a cathartic justice in that. And there is some people whose minds you won't change about mediation on either side, whether it's our clients or our opposition. But a good majority of our cases we do have open-minded parties going into a mediation. And even if it's an initial reaction of, oh no, I don't think that's going to solve it, the only way we're going to get through this is to go to court, being able to have the good relationships that we have with our clients and with our managing agents, especially, to be able to say, look, you go and see these leaseholders, you see them every day. We think that there is something in being able to mediate. What can we do to get people around the table and make that happen? And being able to have those conversations rather than just writing off, oh, parties don't want to engage, let's crack on. It definitely has seen an uptake in the mediation. And quite frankly, when you say to clients, look, you could spend X amount of, hundreds or thousands of pounds on litigation, or, in 6 weeks' time, we can have a formal mediation. It's going to cost proportionately much less. And you've got a wider range of options in terms of resolution that you can kind of engage with in mediation, because you don't have the sort of strict jurisdiction of the court to take into account what can and can't be ordered.
Yeah, and sometimes it's just from a human element, get people around a table and have a conversation about it. A bit like you were saying earlier about your family department and the increase in divorces and that sort of thing. Actually, it's a bit like couples counselling or something like that, isn't it? You just want to, sometimes you just need that human element to say, look, actually, if you do it this way or that way, or what about this, and bring in a bit more to the table that, because people are very focused, aren't they, on what they want ultimately, and what they want to achieve, and won't differ from that. But it's great that, as you say, 6 weeks' time, we can do this meeting and we can get it done, and that'll be that.
Yeah, absolutely. And I think sometimes being able to give an objective perspective on a particular dispute, because you've usually got one party thinks X, the other party thinks Y, being able to offer a sort of slightly objective Z, saying, that takes into account your view, that takes into account your view, and actually that gives us an end goal to work towards, and seeing if the people around the table can reach a point where that's acceptable to everyone. Encouraging a little bit of compromise and give and take. And I think I'm a huge supporter of mediation. I've done a number of them, formal and informal mediations, and certainly something that I've learned from a particular mediator that I've worked with quite a lot, who teaches mediation and does sort of podcasts and webinars and things about it, is that you really have to go into any sort of ADR situation with a mindset of, we need to get this settled, as opposed to, we're here because we're required to be here. And a lot of the more successful mediations that I've seen are very much where we can have those conversations with our clients before we go into the settlement discussions, and say, okay, look, I appreciate that you're really frustrated about whatever the dispute is, or this is what you really want to get out of it, but let's just take a step back, have an open mind, listen to what's going to be suggested, and see if there's any way we can budge on our expectations and what is acceptable, and figuring out those boundaries at either end of what our client wants to get out of it. And that sort of pre-mediative work is really crucial, and it's something that certainly I'm spending a lot of time professionally being able to develop.
Okay, that sounds great. Can you share a memorable case, obviously again without names or companies and everything, but something that had a significant impact on your career?
One of the most memorable cases I've been involved in was last year in the Supreme Court. Well, the case is published. It's the A1 Properties case. We were involved in that from the appellant perspective, and actually not necessarily the legal case per se having the impact on my career, but at the time I was a senior associate. I'd recently found out that I was going to be offered a seat on the partnership team, and sat there at 31 being able to prep for a case that's being heard in front of 5 law lords was incredibly pivotal case for me. Because I think if I could have told my 21-year-old law graduate self that I'd be working in a team that has cases heard at our highest jurisdictional level in this country, I probably wouldn't have believed myself. Because coming out of law school, I absolutely wasn't top of my class. I graduated with a 2:1 degree, had no idea what postgraduate courses that I would need to go on. I didn't have any connections in the legal industry. I didn't have vacation schemes or training contract interviews lined up, and to be completely honest, didn't know what a training contract was, or that I needed one to qualify. So figuring all of that out, and effectively 10 years later, having a case that was at the level that we were heard at, was such a pinch myself moment.
Yeah, I mean, that's incredible. And it leads me on to my next question, actually, that you won Professional of the Year at the News on the Block Awards last year. How do you feel about that?
To be honest, it's still incredibly surreal. Especially the PMAs, the competition was incredibly difficult. We all sat there at our table, Jodie, looking at your presentations and things like that, and the work that you do for the charities. And the guys in the office said, well, I don't know why you're even going to go, Em.
Oh,
because the work you do is incredible, and the stuff that you do for the industry is incredible. So to be quite honest with you, I'm not entirely sure how that happened for me. I'm very thankful to the very kind people that wrote lovely testimonials, which I'm sure helped. But yes, very surreal career moment, both at the EMs and the PMAs last year, because the sector is only something I've been involved with for the last just over 4 years. So to have the level of industry recognition that comes along with that was incredibly surreal.
So I think you're doing amazing things. You talk on this very, as you say, crazy change or ever-changing topic so confidently at conferences and stuff like that. And you're just doing incredible things. So you should be very proud of what you've achieved, and the award obviously last year. But do you see any changes or trends that you're seeing in maybe service charge disputes, or changes in how you address them? Of things moving in different directions with service charges?
I mean, service charges is really interesting. So from my perspective, I get involved in service charge disputes when they hit the tribunal. So we have a separate service charge debt recovery team, which again is probably quite unique in that they're not dealt with within our property litigation team per se. We have a team set up specifically that work with a lot of our managing agent clients and have processes in place to make that as streamlined and efficient as it can be, to make sure that we're working with leaseholders, we're ensuring that there's proper debt collection practices in place. So they come over to the property litigation team when we're seeing defences that are entered in the county court money claims process that effectively equate to a section 27A reasonableness challenge. And we are seeing the county court utilise that ability to pass cases over to the tribunal more, especially following the sort of double hatting trial period they had where county court judges could sit as tribunal judges and hear these cases. A lot of the county court, whether it's because they're busier than ever before or whether they are trying to become more efficient in how they manage cases, I don't know, but they're definitely batting more cases over to the tribunal to hear the reasonableness challenges. One of the things that we're certainly seeing is people understanding more, and whether that's because the industry is now sort of more in the news, more discussed, more talked about, or information is more accessible. We're now seeing a huge uptake in people understanding what that actually means. It's not just I don't want to pay my service charges or my service charges feel too high. It's people understanding that there needs to be reasonableness, proportionality. They have to be recoverable under a lease. Leaseholders really understanding what their rights are, which is an empowering thing to see. You know, it's not, you know, people just don't have a clue and don't pay their charges, and actually being able to be in a position where we're either acting for leaseholders or defending claims against leaseholders, where the tribunal is involved, people having an initial understanding of what that means, certainly, you know, makes my job easier, which is great, but also really actually utilises the tribunal for what it should be used for, as opposed to just being a forum where people can, you know, sort of stamp their feet and say, I don't want to pay this.
Are you finding that obviously people are knowing more because they've been a leaseholder for quite a long time, and therefore they understand and they know, as you say, they know their rights, but they also understand their obligations as well. How are you finding it if it's maybe a first-time buyer? Is it a case of, I've said this quite a few times, that, you know, there isn't a lot of knowledge for estate agents potentially when a first-time buyer is coming in to understand leasehold and what their obligations are. Are you finding that is coming up a bit, like first-time buyers saying, oh, I didn't know I had to pay a service charge, or I can't afford to pay a service charge because I wasn't told I had to pay one, or anything like that?
Absolutely. I mean, certainly not as common as some of the other challenges. But what I do think, as an industry, we can do better is making sure that first-time buyers buying their flat, you know, getting on the property ladder, which is more and more difficult, and flats being a more accessible way to take that first step on the ladder, is making sure that that information is available and in an easy to digest format. So, for example, at our firm, I work really closely with our residential conveyancing team. Any leasehold matters that we deal with transactionally, whether it's a sale or a purchase, they get signed off by my team and the residential leasehold team to make sure that the information we are giving to our clients, and especially marked up if they're first time buyers of a flat, is service charge information in a digestible one-page sheet. You know, this is what you pay, you know, this is what the owner paid last year, this is the predicted cost for next year, this is what service charge means. And they get that additional information from us as to what happens if you don't pay your service charges, things that can and can't be recovered, and almost effectively a tick list of things that they can expect to see. You know, you can expect to see a budget, you can expect to see a service charge demand once, twice, 4 times a year, whatever the lease says. You can expect a set of year-end accounts. You might expect a balancing charge. You know, they get that information. And I think as a sector, especially in conveyancing and sort of estate agents, we should be doing more to inform buyers of leasehold properties and sellers of leasehold properties should be open about what charges look like. And you know, I appreciate some don't want to necessarily say, oh, we've just had Section 20 notices in, and you know, you're potentially on the hook for, you know, X amount of thousands of pounds because the roof is going to be replaced. But being honest about that information and making sure it's clear in management packs and, you know, provided quickly allows buyers to make an informed decision as to whether this is something that they can afford. Because quite frankly, it's no good buying a flat if you can just afford the flat, but you know you can't afford the year-on-year service charges that come with it, because you know that's not a healthy or safe situation for anyone to be in.
Yeah, and by the time, I mean, it's going to come out in the wash anyway, isn't it? By the time it gets down the line, it's going to come out, as you say, in the management packs, in the leasehold inquiry forms that we have to fill out. But by that point, that person who's buying is invested in that property, not just emotionally because they find a flat that they love, or they you know, they find the area that they want to move into, or anything like that, but financially as well, because they probably at that point they've paid their retainer to the solicitor, they've probably paid for searches, they've probably paid, you know, for them, you know, various different aspects of, you know, conveyancing and buying a property. So by the time it gets to the point of, you know, there's a Section 20 notice, therefore there's potentially going to be a levy, or there's going to, whatever you're looking at. If you were told that from the start by the person selling, so if the person selling told the estate agent that, it's going to come out, and you're going to lose your sale at that point anyway if that person isn't going to be able to afford it. So you might as well just say it at the beginning. Doesn't really make any sense,
Absolutely.
does it?
No, I completely agree with that. And I think, you know, whether it's, you know, and I have no experience or information, but whether it's estate agents not wanting to print the information because it can affect sales and commission, or if it's leaseholders not disclosing it because they feel that it's not going to encourage a buyer. And, you know, I can appreciate sometimes people do just want to get out of their property for whatever reason. They want a quick sale, but it's not fair on someone coming in and ultimately the rest of the block. You know, if you've got a block, and especially in smaller blocks where that hole in the service charges is going to be felt more prominently, if you've got someone coming in that is going to be in a difficult financial situation, if there's a levy or if the service charges have to increase because the building needs more repairs, that's going to be felt by all of the people in the block, and it's just sort of unfair. Which I appreciate it's not a legal term, but you know, it's just not fair on everyone else.
Yeah, no, I completely get that. And so talking about your own, if you don't mind, your own sort of well-being and stress tactics and stuff like that, you're going up against some quite angry individuals sometimes, I'm sure. How do you manage your own stress, certainly with complex, high-profile cases?
That is a good question. It's certainly something that I am learning to do on the job, probably more so at this stage of my career than anything else. And I think the huge benefit is things like mental health are so much more openly discussed now than, you know, even 10 years ago when I was a graduate and a trainee. You know, when I was a trainee, it was very much suck it up and get on with it. You know, you're in the legal industry, it's tough and everyone cracks on. In this day and age, it's obviously so much easier to put your hand up and say, look, I'm struggling. Certainly one of my personal coping mechanisms is exercise. I go climbing, I go running, I play netball, I go to the gym. Like, for me, that's my outlet and being able to switch off from the job. I think in our firm generally, we're incredibly lucky that we have really good mental health first aiders. We have a wellbeing committee that put on events or sort of small gestures and things in the office. Over Christmas, for example, we had things like Christmas ornament decorating and, you know, mug decorating and things. You could take half an hour away from your desk and you know, do something a little bit crafty. And we have access to a really amazing app called Help at Hand that our firm pay for us, which gives us almost instant access to talking therapies and also to GP medical care that we don't pay for. So, you know, if you are having a really rough day and, you know, you've either been in court or you've had a particularly difficult call, I can pick up my work phone, log into a video call with a trained therapist and just have half an hour where I get that off my chest. And sometimes that's everything that you need. You just need someone that's not involved, that doesn't really know you, to just vent it out and listen. And I think recognising that you need that is probably the most important thing. In our team, especially in litigation, the team appreciates that there is times where we're all up against deadlines. We have either difficult oppositions or difficult clients, or the court has lost the bundle of papers that you've just spent 3 days preparing and sending to them. You have to do it all over again. There is times where you all feel like you want to run into a wall. And as a team, generally, we work open plan. I go into the office several days a week, as do my partnership colleagues, and our junior team members are in the office generally most days, so that they do work cohesively and we can all kind of keep an eye holistically on each other. And something that we definitely do as a team is recognise when there is a bit of pressure going on, and it's normally a deadline week or a hearing week, or particular influx of cases, or someone's been off poorly or someone's on holiday, so we're sort of coming together as a team. We have a lot of snack breaks. I think Deliveroo and Uber Eats are kept in business by our teams. But even if it's something as simple as, we come into the office 20 minutes early and we order breakfast into the office, because we know we've got a day coming up where people might get a bit stressed, a bit ratty at each other. And then at the end of the day, we always have a few minutes where we just sort of decompress as a team, have a bit of banter, a bit of a joke, make sure we've checked in with everyone, that we're not going home ready to have a cry in the car. Which is great. And I feel incredibly privileged to be part of a team and a firm that really supports our ability to do that. I've very much worked at more traditional firms where, it's you come in, you do your job, you go home, and I can't criticise. There's obviously very good traditional firms. Something I particularly like about my firm is we kind of break a lot of those moulds. It's probably not the most traditional law firm. It's very open plan. It's very modern. You're given the scope to embrace an individuality. Certainly, that's one of my biggest praises about where I work, is I'm not quote unquote forced to work in a particular style. I'm not expected to solve problems and run cases in a stringent way. I'm given that freedom to run them in the way that I think is appropriate, and to run my team in the way that I think works best. So I think that as a sort of combination really helps manage a lot of those stressful situations, and making sure our junior team coming up and through struggling with things like stress, and we can give them the coping mechanisms that perhaps we weren't given 10 years ago to deal with them.
Oh, that's brilliant. I love that you're given is it autonomy, is that the right word? They trust you. I think that trust is a massive thing, isn't it? When you're working with people or managing people, you trust them to do the job. You're not sat there clock watching and saying, "Oh, that's the second cup of tea they've made in 20 minutes." I'd be screwed if
I would. I drink
I'm
a
fueled
lot
by
of tea.
caffeine. So
absolutely, yeah. And I think that's it. We, as a team, generally we don't have time recording targets and things like that. So there isn't that archaic pressure of you must record 7 chargeable hours of time every day. Quite frankly, in this day and age, just doesn't sit right. And like you say, if I had to time record every time I popped off to make a cup of tea and have a little break away from my computer screen, I would be working until 3 a.m. to time record those 7 chargeable hours.
Yeah. My next question would be advice that you would give to the younger generation, people currently in law school, about, potentially working in this industry. The fact that you work in such a great company, a progressive company, I suppose, as well. What advice would you give to newbies coming up?
The legal babies.
The legal babies.
Something that I really enjoy doing, which is kind of separate to my day job, if you like, is working as part of a mentor programme at Montfort University in Leicestershire. So I did my postgraduate there, and they have a really amazing employability programme, which is extracurricular. And they work with not only the law faculty, but across all of the different programmes. But I'm involved specifically in the law school mentoring programme. So quite regularly, I'll go in and speak to law students and lecture on employment skills, things that I didn't know at 21. So I touched on earlier, I honestly went and did my degree with no legal work experience. I didn't understand the legal industry. I didn't know what my next steps were. And to be completely honest, I didn't know the difference between a solicitor and a barrister. I didn't know the different courses you had to take. And I sat in my lectures listening to people going, oh, well, I've got, in the second year of our degree, I've got training contract interviews, because you traditionally used to apply 2 years before you'd start your training contract. So the second year of your degree, you'd then do your postgraduate year. and then you start as a trainee and train for 2 years and then qualify. I didn't have a clue that any of that really existed. So one of the things that I concentrate on when I'm sort of giving those mentoring lectures is really look at for your next step, look for that information, and I think it's probably a lot more accessible now than it was 10 or 12 years ago, when social media wasn't as prevalent. There wasn't sort of influencers and things like lawyers on Instagram talking about their story, and I don't know, I'm not on TikTok, but I assume there's TikTok equivalents.
Yes, probably. I'm too old for TikTok too.
As my team told me, I'm old because I use WhatsApp. Apparently that puts me in the category of being an older person. WhatsApp is not cool anymore.
Oh, who knew? Well, that's me put in my place then.
All of us was. It was when my team said, we had to download WhatsApp so that we could get in touch with you. So
what's the new cool thing to talk on then?
I've gone back to texting.
Oh, okay.
We've looked all the way around and we're back at texting or I suppose Instagram messaging and things like that.
Oh, well, maybe we're just too cool for them. It's fine.
I'll take that. I'll take that. But having that information accessible, although not on WhatsApp, is probably more beneficial to the students now, but really encouraging them to look at different options, fading out the LPC, and there's the SQE programme, and that's obviously more sort of focused on making sure people have the relevant work experience skills and not taking your postgraduate and then really struggling to get the training contract in a firm. So I think the Law Society has already started to do work on helping improve accessibility. But things like vacation schemes, taking advantage of work experience programmes, it is really important. And networking, learning how to network is a skill that you don't learn on your degree. It's difficult to teach if you don't just throw yourself into those situations where actually you can go and meet industry professionals, you can go to lectures, you can have the confidence to go and ask a question and connect with someone on LinkedIn, which is obviously a huge virtual network, I suppose, but which wasn't really accessible when I was starting out in my career. And really actually finding something that makes you stand out in the crowd and not just being another application on someone's desk, not just applying for every single job because you need a job, really applying for the jobs that that you want, you've researched, they're firms that you want to work for. That was an absolute mistake that I made, is I just took any job that I could get to get into the sector. And I had some really positive experiences, but I had some really negative experiences. I sort of left a training contract firm that I'd started my training contract at and finished my training contract at a different firm because it wasn't somewhere that I was particularly supported or could see my career developing. So having those positive and negative experiences, although built me into the lawyer that I currently am, were difficult to navigate. There's a lot that we can do to support the generation coming up and through if they want the support.
You're not taught life skills ultimately, are you? Even in school, not sure if I've ever used the Pythagorean theorem or whatever the right phrase is, or trigonometry or even algebra, but I could have done with some help with taxes and mortgage applications and all that kind of stuff. So yeah, it's the same principle, isn't it? And networking, I mean, at 41, it's crazy because I can stand in a conference and do a talk on lone working or something like that. But to actually go up to somebody and say, "Hi, I'm Jodie, nice to meet you." I went to a networking thing years ago when I was probably late 20s. It was an RICS one. And they said to me, "Oh, what do you do?" And I said, "I'm a block manager." And they literally turned and walked away from me.
Gosh, how awful.
I think that just... I wasn't the most confident person in the room anyway. So to have that, it just completely put me off. And I didn't go to a networking event for years. But I'm a bit more of a social butterfly now. But still, it is hard, especially when you're younger.
For sure. I think there's definitely something to be said about the ability to put a different hat on, almost that fake it until you make it confidence, because I can completely resonate with that. Even now, going into a room full of people and sort of not recognising anyone at an industry event, it's so intimidating. And it's very different when you're getting up and giving a presentation, because you know what you're going to say and you've got people's attention generally, apart from when you're having to give the legal update at 5 o'clock.
I was going to say, you always get the last slot, Emma. It's
always the last slot. Always the last slot. And it gives everyone an excuse to disappear early so they don't need to listen to it. But it's very different when you go into the drinks reception at the end and suddenly you've got to go and find someone to talk to. And it's very easy to find people that stand with them and stay with them, not really expand your network. And for me, that's where LinkedIn has really made a difference, because I can connect with people and say, I'm going to this event, come and say hello, and you can see who's there and be like, oh, I saw your LinkedIn post, or I can see that this is what you've done recently. And it just gives you that little bit of something to open a conversation with. But it takes a little bit of prep. I'm so terrible with faces and names that I'm sort of like, I know who you are, I recognise you, but I haven't got a clue what your name is.
Yeah, and I think that's in some ways that what you said about, if you see something on LinkedIn, that is the benefit of social media, isn't it? Because if you are a bit shy, you're not quite sure what to say to people, you can be like, oh, I saw your post on whatever topic the other day, that you can have some common ground with, and just finding that. And if you're not very good at creating conversations from out of nothing, having that social media presence that you can look back and think, oh, I really liked your post the other day on such and such, and it creates that conversation that becomes more natural then.
Yeah, absolutely. I think it's definitely the benefit of, certainly for me, LinkedIn, like the professional social network.
Yeah, there are some benefits of social media, I'm sure. So what skills do you think are essential for success in property litigation?
I mean, I think that's probably different for each litigator. Part and parcel of that is knowing your topic, knowing the law. That's got to be the underpinned essential, because you can't argue something that isn't written into the legislation or isn't in case law. And those abilities to find those answers and understanding both sides of an argument. I have generally worked in litigation for my whole professional career, bar the odd sort of detour out. It's almost a personality aspect. You either want to do litigation or you don't want to do litigation. It's a bit of a joke amongst our team. It's you're a litigator or not. And so there's got to be an aspect of resilience in a personality to do that, and problem solving skills. So when I went to uni at 18, I was diagnosed with severe dyslexia, which I didn't know when I was in school, because I had really pushy parents that were like, you will sit down and do your homework, do better, you will pull your grades up. So, I was never really diagnosed at school because I didn't outwardly struggle. I was always pushed academically, and I'm so thankful to my parents for that. But on the flip side of it, it definitely hindered a diagnosis so that I could get support. So when I went to uni, I was really thankful that we had a great SEN team that could diagnose me as an adult and provide that different support package, and learning things that I struggle with and how to combat that, and learning different problem solving mechanisms that work with my brain has been probably the biggest strength I have in terms of litigation, because the way that I think through a problem is potentially different to how one of my colleagues would think through a problem. And actually having that cohesive teamwork, I work really closely with Roger Hardwick, for example, and he knows the law, he knows the sector, he knows everything. He's like an oracle, pure knowledge, just like this little glowing sphere of everything about the leasehold industry. And being able to sit next to him and saying, this is the problem, this is where I've got to, this is how I think about it, and hearing his view and going, well, I would never have gone down that way because, X, Y, Z, I would have thought about this. And that cohesive approach of my maybe slightly different way of seeing a problem and his superior leasehold legal knowledge is just really, really effective, I think, for our team. It's probably our hidden superpower.
People see ADHD as people just, or little kids running around like little crazies, but actually the benefit, really hyper focused on something and get something done 10 times quicker than somebody who isn't neurodiverse. So, but yeah, I love the fact that you've said that about, sort of complementing each other in terms of how you think. That's really great. And I suppose encouraged by the way that your team work anyway, as you said earlier. A couple more questions. What's the most rewarding aspect of your work?
I would say the most rewarding part of our job is actually being able to get to a stage where we've resolved disputes, quite happy clients at the end of it. Litigation clients are never happy. We don't get bouquets of flowers and bottles of wine like conveyancers do. And I hold that with a deep grudge that our transactional colleagues get bottles of wine and flowers sent to them. We save our clients sometimes hundreds of thousands of pounds, and we get a grumpy, well, I've paid your bill.
Yeah.
But there we are. Not that I'm bitter about not being sent flowers.
I'll send you some flowers.
Thank you. But no, the resolution of cases, and actually in this day and age now, being able to make law effectively, because some of the cases that we've had heard are really paving the way. That's incredibly exciting for me as a lawyer. No one else would find that exciting.
You know, everybody has their thing, don't they? You know, the fact that when I get a good outcome from something, or I do a major works project, and even though it's cost them, as you say, thousands of pounds, their building now looks 10 times better, or it's been restored to its original beauty, if you like, and that's really rewarding for me. So I do get it, but as you say, you don't tend to get a thank you because they've spent all the money doing it.
I think a lot of property managers probably feel exactly like that. You walk into a gloriously renovated building with a lovely concierge, setup, and you look around, you go, yeah, this wouldn't have happened without me, but no one's coming down to give you a little pat on the back and say thank you for organising the spending of tens of thousands of pounds so our building is habitable again.
Yeah, that's all we want. It's a pat on the head like a dog. I'm just like a little puppy, really, like love me. Just finally, and I know obviously you're still in your 30s, but what legacy do you hope to leave in the industry?
That's not something I've ever really thought about. I don't
Got
think.
A few years left of working.
I hope so, unless I win the lottery, in which case you'll find me on a private island somewhere, probably not reading any more building safety legislation. To be honest, I haven't actually thought about leaving a legacy. I think because I still feel very new to the industry, comparative to a lot of my colleagues and counterparts across the industry that have been doing this for decades. I've been here for 4 years, so I don't even feel like I've started to make a footprint yet, let alone a legacy. But it would be great to be able to just encourage the next generation coming through, whether that's litigators or property managers, or even something, from an educational perspective where leaseholders are given support, whether it's at the purchase stage, whether it's with something like building safety, being given accessible information. And that accessibility aspect is important, obviously, as someone with dyslexia. If someone sends me a big load of information, it's the most intimidating thing to land in my inbox. And obviously it happens a lot as lawyers, but if I can provide something that is more digestible and more accessible in the leasehold sector, I think that I would strike that up as a big achievement.
Well, that would be amazing. So before I let you go, how do people find you if they wish to do so?
Under my desk, in the snack drawer. Hiding from the next lot of building safety or leasehold reform legislation. We're online. Our website was beautifully refurbed last year by techie wizards, so it's very accessible, mobile friendly, that sort of thing. They can ping me an email. My email is emmabush@brethertons.co.uk, so nice and easy to remember. Or LinkedIn. More than happy for people to ping a message to me if they've got questions, or God forbid they want to come and speak to me at an event.
They got to wait until 5 o'clock for your presentation.
Yeah, you have to be in my presentation at 5 o'clock, otherwise I'm not interested.
Absolutely.
We need to keep the bums on the seats.
Yeah, well, I like your presentations. I always think they're very good. But thank you for today. I really appreciate it.
Thank you so much, Jodie.
Yeah, I will pop all of your contact information in the show notes.
Perfect. Thanks so much. I really appreciate the opportunity.
Thank you so much for taking the time to listen to my latest podcast. You can find me on LinkedIn and Instagram. The links are in the show notes. Or you can contact me on jodie@jodiefraser.com. For more content and updates, don't forget to subscribe to this podcast on your favourite platforms. Thank you once again for listening. Until next time, take care.